SJC-12345, Commonwealth versus Kennedy.
Mr. Schnipper, good morning.
Good morning, Chief Justice and everyone. Welcome to Greenfield. May it please the court, I'm Merritt Schnipper on behalf of Christopher Kennedy. One of the most basic principles of the criminal law is that we punish guilty minds, not just acts. Yet the jurors of the trial here were prohibited from considering the defendant's state of mind or what he thought was happening between himself and his accuser when he took the acts for which he was convicted. Instead, the jurors were told to decide the defendant's guilt or innocence based solely on his accuser's subjective perceptions of their interaction. Now, that standard is guaranteed to result in unfair trials and convictions of people who harbor no criminal intent whatsoever. It's fundamentally unfair to allow a person to be convicted of a life-altering crime without any showing that they intended to do wrong. Now, the instruction that was requested by the defendant here is solidly grounded in this court's sex offense jurisprudence with regard to the knowledge standards of criminal defendants in sex crime cases. It begins with the Lopez decision where this court basically, while it rejected a mistake of fact defense, it specifically said that in the context of the rape statute, the requirement that sex be compelled by force acts as a proxy for knowledge because no defendant who has to compel another to submit by force could reasonably have believed that other consented to the conduct at issue. So it's not as though there is no mens rea requirement in the context of sex crime cases. The alleged victims, the accused knowledge of the alleged victim's consent status is always an issue to some extent.
So you're talking about your client's subjective perceptions of consent.
I'm talking about, right, his understanding of what was happening between him and his accuser. And in this particular context, it's really an unusual, or it's perhaps it's not.
And the fact is you lay out in your brief, and the facts are largely based on these text messages.
Online exchanges and text messages.
What other factors would come into one's subjective perceptions of consent?
What other factors besides the text messages? So there would obviously be the entire, what I would call the written correspondence between the parties through these texts. And one thing I think that makes this case at least sort of a newer take, although one that may occur more frequently now that this is a common mode of communication, is that obviously the texting lacks some of the subtle inflections, body language, expressions, other things that contextualize words in a lot of human interaction. So besides the text messages, there's the time that they spent together at the gas station, having a coffee. There's the bit of phone calls that they've had with each other. There's the invitation back to the home, the entry to the home, and then the actual offense conduct occurs.
Other factors that could come into play, would they include a victim's reputation?
No. I mean, what we're talking about here, so we're not talking about anything that's in rape shield statute.
Well, no,
zone.
I think that the issue is whether or not your position gets there.
I don't think
because if a defendant were to say, I heard that she was promiscuous,
sure,
and subjectively, I thought that I had consent, would that be something that would come into play?
We would not consider that to be a factor that would justify getting the instruction in any case. So I think, again, we're asking for a standard.
You're going to accept that the victim's reputation would be accepted from your view of a mistake of fact.
It would be excluded.
Excluded.
Yes, it would not be a part of the consideration because it's not about the interaction between the parties, right?
It goes to his state of mind, though, doesn't it?
Well, it goes to his state of mind, but there's state of mind and then there's state of mind. The state of mind.
Get that legal standard. State of mind and then state of mind.
Sure. So the state of mind based on the actual. So there are things that are going to be legally excluded.
I know maybe you don't want to get into rape shield because it's not good for your position.
Well, it's really not relevant to our position. I mean, our position is based on crimes that are alleged to violate normative standards of conduct, and we're asking about whether a particular person's reasonable belief about what was going on between them and their accuser is something that a jury can consider.
What about the victim's manner of dress? Would that come into play?
No, it would not. So, let me just point the court to, I think, with the excellent amicus brief from CBCS on that issue that discusses things that would not be part of the calculus, and I haven't listed them in my brief because I never considered them as part of the calculus. The calculus here has to do with the interactions between these two individuals, right? So now, obviously, if somebody said, well, wear a red T-shirt if you want to come home with me, and then when you meet me and they wear a red T-shirt, could that be? Sure, just like say yes if you want to come home with me could be. But if it's a particularized piece of communication, and communication is not only about words, it's about body language, it's about expressions, it's about intonations.
So we're to write a rule of law that says that subjective perceptions of consent are admissible, but we're going to accept from that a victim's reputation and offensive gender-based stereotypes about manner of dress as well?
Well, I would urge you to exclude both of those, but it's not as though no one is suggesting that offensive gender-based stereotypes in either direction should be the determining basis of whether this instruction is needed. What should be the basis is what would a person who was interacting with his or her accuser have thought was going on at the moment they took the conduct for which they're alleged to have, committed a criminal act. So if when you overpower someone with force in the rape context, the court has said we're going to read into that statutory requirement that there is no reasonable possibility. You may have just totally subjectively thought that this person was consenting, but that's not the question. The question is, it's just like this court said in Mountry, it's like a third-pronged malice standard where there's a hybrid of subjectivity and objectivity. What would a reasonable person possessed of the knowledge that this defendant had, based on all the surrounding circumstances, what would a reasonable person in that situation have thought were the risks created by their conduct, or in this case, would have thought.
What about when an alleged victim says no?
Well, when an alleged victim says no, obviously, we're going to be thinking that that's a pretty clear indication of non-consent. So any conduct taken beyond that point is going to be very difficult to claim that that's reasonable, right? So if you're going to the facts of this case, so then there's two crimes charged, right? One is a there's three crimes charged, two sex offenses. One is a non-contact offense of indecent exposure, and that entire offense conduct occurs before
Or the no?
before the no testified to by MM. So that's the very first inquiry that needs to be undertaken is with regard to the indecent exposure charge, is this instruction justified on the facts of this case and under this court's precedents? Then when you get to the second indecent assault and battery charge, what you then have is a question of did he reasonably believe it at the time that he initiated the contact, and did he behave reasonably once he was clearly informed that there was no consent given? So that's the question for a properly instructed jury. And the entitlement to the instruction, as I've said in my brief and pointed this court to its self-defense precedents, really needs to be looked at in the context of affirmative defense case law that looks at the evidence in the light most favorable to the defendant. So
Let's pick up on that, if we could, please, and put aside whether or not an instruction would be appropriate as it relates to indecent exposure.
okay,
So, as I understand it, your client didn't testify.
He did not.
We're looking at this in the light most favorable to the defendant, however, on whether or not there's an instruction available if one, under the law, should be available. So we're taking the facts in light most favorable to the defendant. Defendant doesn't testify. The victim says something like, no means no, and I didn't expect this to happen, and everything before she gets up against the wall. So whether Blaché gets extended or not gets extended, if we fill in what we left open in Lopez, in the light most favorable to the defendant, other than the indecent exposure, how does your client get the instruction?
Well, because he gets the instruction because, first of all, I think it's very important to consider the fact that, as defense counsel said, if I get this instruction, my client will testify. So,
Work that way.
well, it
though.
may
You
not
can't
work that
say-
way, but when you're thinking about the policy issues about getting the fullest view of the evidence, I think it is a relevant
So
consideration.
in a murder case, the judge has to make a decision when the Commonwealth rests whether or not he's going to give a lesser included offense instruction on manslaughter, so that the defendant knows whether or not to testify. Whether it's prudent or not to do that, as the Superior Court judge put aside. You don't get an
right.
anticipatory ruling. That's not the way the world works. So
No, I'm not talking about in this case. What I'm talking about is the policy considerations. Do you think about the possibility of this instruction being out there in future cases, how it will shape the truth-seeking progress
and I'm homing
process?
in on your case.
All right, so in
But
my
your
case, yes,
in the light most favorable to the defendant,
right,
assume without deciding the indecent exposure.
okay.
Then you've got at least 3 no's before there's any sexual contact? Why do you need more than one no?
You don't need more than one no to decide that a crime has been committed. But what you need the instruction for is to allow a jury to, because it's not 100% clear from her testimony what the exact timing of the first contact is, which is when the crime has been accomplished versus when it becomes clear to him. Because one of the things that's most important, and one of the things that in the light most favorable to the defendant demonstrates a lack of criminal intent, is the fact that he gets the message when she says, "Get the bleep out of here." He backs off, says, "Oh my God, I was wrong. I didn't realize that this wasn't what was happening. I apologize, and I'm going to leave." So I would say that's a fact in the light most favorable to the defendant, strongly in favor of the requested instruction. And it's a light that is a fact that makes it, I think pretty reasonable for a jury to conclude that this was a mistaken perception of what was going on. We then go to the second prong and ask whether it was reasonable in light of the normative standards that inform this offensive sex crime. So, that's how we get to the light most favorable to the defendant to get the instruction in this case without his testimony.
But if that's right, then, well, let me step back. Do you accept the amicus standard that says that you would get such an instruction only when there is evidence that the victim reasonably signaled affirmative consent to the conduct that occurred?
So yes, if the alleged victims, if the evidence of her conduct is taken in the light most favorable to the defendant, and the reason I think this case highlights the way that standard needs to be applied so well is that there's a tremendous amount of evidence during trial developed about what her internal perceptions and her internal motivations about sending these texts were. The Commonwealth spends a lot of time, for purposes of establishing non-consent, talking about, well, what did you really mean when you said, "Are you going to bring the gun in your pants to my house? That when you come out to my house and make me scream in the woods, you'll bring your handcuffs?" And when she says, "Oh, I was just goofing around, I didn't really mean that stuff," I credit her that she didn't. But why would a person receiving those messages reasonably believe that they weren't intended as they were written on the page or on the screen?
But the problem I have with your argument is I understand your argument that seductive, inviting behavior can reasonably be relied upon, but not after the person says no.
No, that's correct. I agree.
That's the problem I've got with the indecent assault and battery, is it followed her saying no. So as a matter of law, shouldn't we say that whatever may have happened before, no means no? In fact, she said no means no, but...
That was the testimony. So what you should do is this. You should ask yourself whether the properly instructed jury may have viewed the credibility of her testimony differently. Because the point here is that the jury is analyzing an entire course of conduct, including both everything that led up to the moment of contact, her statements of no means no, his statement of apology and retreat. So that you really have to look at it the entire. So if the question is,
That's the consent issue. You can't confuse the consent issue with the subjective, objective, third prong of malice state of mind.
Right. So
here's the
Yeah.
just be sort of blunt about what the problem is here and the disturbing issue that we have to resolve is this woman gets to say whatever she wants to say in her text messages and have every intention that she wants to have relative to whether or not there's going to be a sexual encounter. And then she gets at that last minute when he's in the house to say no once. And you don't have to say no 3 times, you say no once, and everything that happened before it evaporates.
well, it certainly does in terms of actual consent, but in terms of the impression that a person has, I think that's the question for a properly instructed jury. And what I would push back to the court is the question of why we are so intent on keeping a crime that's based on normative standards of behavior out of a fully informed jury's determination. So if we're basically saying it's quite possible that a properly instructed jury in this case would have convicted him of indecent assault and battery. But the question is, and again, it's not a question of some sort of prospective actual consent being given. It's a question of what a reasonable person would have believed over an entire course of conduct between the two. And you're right. As I say in my brief, I believe, or either way I'm saying it now, the longer one of these interactions goes on and the nature of the behavior between the parties once contact is initiated, the length of that interaction, like the reasonableness of a belief is going to decline precipitously as time passes, within seconds. But that doesn't mean that at the moment of the contact, which is the criminal act, there was not a reasonable belief, and not a reasonable belief that the community would validate as reasonable based on normative standards. So then if the question is, was there a continuation through the no and then a separate crime committed with a second bit of contact, well, that's really a separate question for a jury, right? Rather than just kind of this one size fits all, well, did he behave, because what we're really here now is, did he behave wrongly or not?
But I'm confused. Are you suggesting, I mean, given that we've got to, for these instructions, take the evidence in the light most favorable to your client, right? So are you saying that whenever anyone sends a suggestive text suggesting consensual sexual activity, you know, in the course of their communications, you're going to get this instruction because he may have taken that suggestion from before as applicable now, including to the point where he exposes himself the moment he walks into the door of your client?
Well, I'm certainly not saying that based solely on a suggestive text, you would get that instruction.
But that's what we've got here. We have suggestive texts and a willingness
there's
to meet for coffee.
Well, there's an important fact that I think you're eliding, which is that they meet for coffee. They've never met before in person. They meet for coffee for 10 minutes. He says, I'd like to come.
He asked to
All right.
come over.
He says, I'd like to come back. She says.
To finish the conversation, right?
Sure, and you might recall that one of the prior text messages says, nobody's coming back to my house unless I'm sure. Again, open to interpretation, but the question here is whether, and when they meet for coffee for 10 minutes and then drive 20 minutes to her home, could a reasonable jury conclude that he reasonably believed there was some desire for sexual contact at that moment? And in terms of his behavior when he enters the room, I'm certainly not suggesting that you or I would do that, but we're dealing with realms of human sexuality that are somewhat.
Every time someone has some kind of text, sexually charged text, doesn't that, and then they meet, aren't you asking for that instruction whenever that happens? Why isn't, it seems like there's something very frightening about that.
Well, I beg to differ because, first of all, we're not talking about crimes that involve force. So we're not talking about rape, we're not talking about harmful, indecent assault and battery.
We're talking about this person exposes a sexual organ based on that textual suggestiveness, right?
Well, we clearly are. Obviously, that's what happened in this case.
Right, but so you're saying that whenever someone has a sexually charged text communication, they can get an instruction that justifies that?
Well, first of all, I question the use of the word justification there because we're basically submitting a factual scenario to a jury's determination. So
Well, I'm recognizing what you're saying, but I'm just taking into account when we do affirmative defenses, we get instructions based on the light most favorable. I take it that any case coming forward, we've got to give that instruction then. Any sexually charged communication which suggests there's going to be some kind of sexual contact.
Well, let me say, I think it would be certainly something that would come up with a frequency in non-harmful indecent assault and battery cases and perhaps in indecent exposure cases. The question is then, would the jury verdicts that would result actually be more fairly based in the evidence and be more fairly based on an assessment of what happened between these parties and whether it's behavior on a defendant's part that justifies criminal sanction, and including referencing the case that came before, lifetime sex offender registration, a potential in this case of up to 5 years in state prison. So I don't think, we're not really talking about a light issue for the defendant there either. So, I mean, I think to the extent, and that's why we take it in the light most favorable to the defendant, because it's the defendant who is really hanging on some very serious consequences here if such an instruction is denied.
Okay, thank you.
Thank you very much.
Welcome back.
Thank you, Chief Justice. May it please the court, Cynthia Von Flatern, Assistant District Attorney for the Northwestern District for the Commonwealth. The Commonwealth would ask that this court, because of the facts of this case, decline to answer the reported question, the question that was left open by this court in Commonwealth versus Lopez. There was no reason to give a mistake of fact instruction here, and I would point out that just to let the court know what the instruction actually was that was requested by defense counsel. He requested that the instruction be, keep in mind that the burden of proof is always on the Commonwealth. So the Commonwealth has to prove beyond a reasonable doubt that a reasonable person in Mr. Kennedy's position, considering all of the circumstances, could not have been mistaken as to whether the victim would find the exposures of his genitals offensive. And then with respect to indecent assault and battery, whether a person in Mr. Kennedy's situation reasonably could have been mistaken about whether the victim consented to the touching at issue.
Don't we have to reach the issue on the non-contact offense? Because I understand what you argue and what's been discussed, that the no means no and all that happens, that goes to the indecent A and B. But there's the immediate non-contact offense that happens before the no, according to the facts. So don't we have to reach that issue?
Well, Your Honor, I think that the court has seen that with respect to indecent assault and battery, that there was no question that there were multiple no's on the part of the victim.
That's what I said. So, but focus on the non-contact offense, because we have all the text messages and the like. So I don't see how we can avoid reaching this issue on the non-contact.
Well, with respect to the transcript and the victim's testimony, I think that going back, and it's pages 96 and 97 in transcript 2, that when this court looks carefully at those pages, that she says, as when the defendant enters, he begins to expose himself, and she immediately says no, and he doesn't put his he doesn't zip up his pants.
But the crime's already occurred.
But it continued to occur. So if it had ended right then, that might have been, then we may be in a different circumstance. But even in terms of prosecution, but the indecent exposure continued before you get to the indecent assault and battery. And you could imagine the victim in this situation, it was like slow motion, I would submit, when she testified to this, because she sees the zipper come down and he's pulling out his penis. She sees his belt. He doesn't take off his belt, but she sees his belt and his gun, his police gun, and she sees him pull out and she testifies. She's saying no, and he keeps pulling out his penis. So it's not like a quick second thing, and that would be the extent of the charge. It was quite extenuating and quite a period of time before the indecent assault and battery ever occurred. So
You don't really want us to draw that distinction, do you? You want us to find, you don't want us, because he kept it out, that makes it an indecent A and B, right? You want us to find just having it out is an indecent A and B, don't you?
Indecent exposure.
Indecent exposure, right? You don't really want us to draw that distinction that if he'd put it away, it wouldn't have been?
Well, with the facts of this case, I would submit that in terms of looking again at the need for the instruction, I think this court can easily conclude no need for instruction on indecent A and B, and no need for instruction on indecent exposure, because she conveyed her that it was offensive to her, so he could have had no mistake of fact. There's no question about that. The elements that the Commonwealth was required to prove is that he exposed himself and that somebody was offended, and she conveyed that to him.
It may be an easier case for the Commonwealth, but I assume you're not suggesting he gets the instruction if he'd put his sexual organ away right away, right? On the indecent exposure, or are you?
No, I'm not suggesting that, but I think that from the point of view of the Commonwealth, including at trial, there would be no need for the instruction, because the no was so clear in the testimony that she kept saying no, and he did not take steps to take steps to remedy the situation, and went further. And then committed 2 more crimes, indecent assault and battery and assault and battery.
So I'm going to press you on the question that Justice Kafker says you don't want to answer. If the circumstance had been that He opens his pants, exposes himself, and she says no. And he says, "Oh, I'm really sorry, I misunderstood," and put it back into his pants. Would he not get an instruction?
Well, I think, and we have talked about this. I think that it's a much harder case, Your Honor. But I would submit that the case law now is that his knowledge in the case law, the knowledge of the defendant as to whether this would be offensive to somebody else is not an element of the crime. So I would say no, he doesn't get it.
So let me give you another hypothetical. Person getting a massage. Masseuse says, undress. Person undresses completely. Masseuse comes in, says, no, I didn't mean completely. I meant just to your underwear. And I'm offended because now you're entirely naked. Crime?
Well, then, no, I would say that's not a crime because it goes to...
And why is it not a crime? Because she was offended and he exposed himself.
Because it goes to I don't think there's any intent on the part of the defendant in that particular
You
case.
just told me that his intent, he has to intend that it be offensive?
No, he has to intend that he indecently expose himself, and here he was given instructions to take his clothes off. So I think that's a different situation.
Which he misunderstood to mean all of his clothes. So how is that materially different? I mean, it's different context, I understand, but I mean, the fact of the matter is, sex is, we hope, usually consensual, and a first step towards it is taking one's clothes off.
I don't think that in that particular case, I don't even think he has any intent to commit the commit the conduct. It was just that he was instructed to do it, and he did misunderstand. But I don't think that there's any intent whatsoever in that particular case. Unlike almost every other kind of situation that you could imagine, if somebody takes off their clothes in a public place and then can't say, "Oh, I didn't think that somebody would be offended by that." That's not I would say that's not a defense. The issue is whether the victim is offended or not.
So, in your view, a person commits, now, indecent exposure, is that a felony?
Yes, I believe so.
So when a person commits a felony, if the person reasonably believes that the other person wishes to have sex, takes his or her clothes off in anticipation of that, and then later learns that the person did not wish it and immediately puts his or her clothes back on and says, "I'm sorry, I misunderstood," that's a felony?
Because I would submit in that case, if it was that there in certain circumstances that there may be a question about the defendant's intent in that particular in some circumstances. But again, we don't have that in this particular
Okay, so
case.
the issue is not whether there should be this affirmative defense. The issue then is its scope and its definition.
Yes. And, the Commonwealth is not aware of, with respect to the indecent assault and battery cases, where the issue about mistake have arisen is when a victim has been incapacitated.
Right.
So
Well, I mean, put those aside. I mean, I'm referring to
the indecent
all of
exposure.
the clumsy interactions between people where a person may reasonably believe there is consent and is mistaken with regard to that, and acts appropriately after the lack of consent is made clear.
So it would tend to be in a situation that it would have to be in a situation that appeared to be like a romantic situation or something, and then a person claims that they truly misunderstood. And I would submit that would be very rare, that there would have to be some evidence on the part of the defendant before one could get that instruction. Here, in contrast, in this case, we have no evidence from the defendant other than these texts from 6 days earlier, one day of texts that are flirty. and sexual in nature upon which this defendant based his argument. So if we had a situation where somebody puts that evidence out there that he was truly mistaken, then that would be a hard case and probably one where a judge would consider giving an instruction.
Is indecent in the indecent exposure statute mean the same thing as indecent in indecent assault and battery, societal norms and what people would be
Well, I believe it would have to be the genitals instead of the genital area.
in general?
In general, that it would be offensive to somebody, that somebody would see it as offensive.
Why instead of having a mistake instruction, wouldn't the issue be whether or not that conduct falls within indecent for the jury to decide when there is a situation where somebody actually reasonably thinks that there's going to be some sort of sexual intercourse or something else?
I think that would be a great way to look at it, Your Honor, and then it really goes to the consent of the victim as well. I mean, in a romantic context, many things would not be offensive to the victim, and the victim would consent.
But there's also what society is in normative values that goes into the instruction on indecent.
Yes. But I think that in any, the conduct that this defendant was accused of and convicted of, I think in any context that would be considered offensive.
So the jury has to decide.
Yeah, wouldn't that be a jury question?
Well, in terms of that he showed his genitalia, that it was, because there could be. It is a jury instruction, just like in exactly what he did. I think that is a jury instruction, yes.
And the jury wasn't specifically instructed on that. They were just given the general definition of indecent.
Yes.
I just want to go back to the chief. Sorry, are you done?
Yes.
Back to the chief's question. So are you saying that in certain, because we've never given this instruction before, right? So are you saying that there are certain circumstances you can envision giving this instruction because you're on a general intent crime?
Your Honor, the only time that I would say, in following from the Chief Justice's types of hypotheticals, would be in the indecent exposure where there is, and I think it really goes more into whether there has been any. The thing with the situation with indecent exposure is it could happen before a victim is able to express non-consent. And that's the difference between an indecent assault and battery in a lot of ways and an indecent exposure. And that's why in this case, the indecent exposure issue is not difficult because she did convey non-consent.
Indecent assault and battery can also happen before a victim can, you can quickly grab somebody, also before someone gets a chance to say no, right? That can happen fast too.
That can happen fast, but I think that then you can consider, but that can happen with enough time that the victim can form non-consent and also convey non-consent. But in the indecent,
That gets back to, you get the post-no conduct is you can back away from the post-no conduct, but I'm wondering about the conduct that happens immediately before the no, and we know that can happen based on, I guess, misunderstandings too. But you're saying you get that instruction then?
well, Your Honor, that it would be there are no cases here where that has there are no cases in this jurisdiction where this court has affirmed giving that instruction. And there might be, the court can posit hypotheticals where it might be appropriate. I would submit that most indecent exposures happen, many indecent exposures happen outside in the public, and there's no question that there could be a mistake of fact. When you're talking about an intimate scenario, then and that was the only charge, so there might be a question in that particular case. But a lot of times it could occur in a situation like this where it's indecent exposure and then it's something else, and it was clear what the defendant's intent was all along, as well as the victim's non-consent. Thank you, Your Honors.